In this case, we have concluded the hearing on several occasions in different courts. And when one time we are acquitted, then suddenly after dictating the judgment, the court came to know that the informant has not been served with a notice. Then notices were sent to the informant. In the meantime, the informant died. Then, my lord, from then many of the accused have been granted bail by this honorable court. Some got bail from the Supreme Court. My lord, there are 16 accused and 16 witnesses are there in this case. My lord, earlier Ms. Jahan was appearing for the state of Assam. Well, I'll pray for some accommodation on, my lord, 29 subject. Subject to your lordship's convenience. On 29th of January, we'll try to finish it off. It will take around 2 days. The last time it took, some courts took around 5 days to hear the entire field because lots of witnesses are there. There are lots of contradictions and all. All those have to be drawn to your lordship's attention. So if your lordships will kind enough to take it up on 29th, then we'll have around 3 days holidays to prepare for the case. 26 is a holiday, 27 and 28. That's our prayer before your lord.
See, we noticed that a lot of adjournments taken by.
Yes,
the
madam.
appellant.
Yes, madam. From our,
It's back to the adjournments. I've
Yes.
seen the last few orders.
yes, madam. Madam, because if this matter suddenly comes now, we also can't get prepared, madam, because we have given the chart and all to the court. And it was hard by at least 3 division plans.
I'm not aware of it, but it was hard.
Land by different division. And I can't pay to be transferred to the division bench because some of the judges have also retired from the under division bench. So your lordship has to hear it afresh. So I'm praying only for this accommodation on 29 because for 26, 27 and 28 will have 3 holidays. We'll come prepared fully for this.
Lordship, but today the office has not provided a copy of the paperwork. I'll do the needful, Lordship. I'll get a
Yeah.
Xerox copy from.
Yes. We'll furnish all the documents to my friend Malapuri. It's a 2015 matter, but it went on for long.
It's a big for finish office for the appellant. Present the matter we insisted on 29. But if we have interpretation or no objection to the state. It has been submitted by Mr. B. Pawar that though the matter has been heard by different benches of this court, same has not been decided fully, has not been decided fully. And the prayer of Mr. B. Pawar, this is the matter on 29.
We are deeply obliged, my lord. Yes. We'll provide.
May I please? I just to mention item number 13.
13. Yes, for about 13.
Yeah, matter may be taken up after Ihu.
After?
After Ihu.
Why? I will take up the 389 petition. You wait. We'll take up the 389. Maybe we'll not decide the hearing, but we'll take up the 389.
May I please, your lordship? In this case, lordship, the respondent has remarried, lordship, with another. The appeal becoming fact, lordship. No, I just came to know that.
Now what to do?
And he has married within the time allowed by the law.
Who has married?
Respondent has been.
Respondent is the wife.
I have got a respondent. He is the husband in this case.
Actually, he's the husband. 5/7/2023. Passed by the Sessions Judge Sonitpur Tezpur. In Sessions Case number 183/2019, by which the appellant has been convicted under Section 302 IPC. Admit the appeal, call for the LCR. Miss
SH work.
S.H.
Bora.
Bora. S.H. Bora appears on behalf of the state. This is the matter after following.
Lordship, I have to take steps upon Espana, but
No need. 302.
Lordship, there is an IS that may be considered after receipt of death.
In the IAU, right, Ms. S.H. Bora, additional PP is granted 4 weeks time to file written objection to the application under section 389. Issue note, that. 4 weeks time, granted.
Lordship.
P-
A copy of the IFAP furnished to us.
May it please the Lordship. This is an appeal against sentence of 302.
Mr. D.K. Bhattacharya appeals for the appellant. This is an appeal against the judgment dated 31/5/2017, passed by the Sessions Judge Morrigan in Sessions Case number 161/2015, by which the appellant has been convicted under section 302 IPC. Same thing, huh? There is no 389 out here.
No.
Obliged. Appeal against 20 years imprisonment under POCSO Act, my lord, under section 4. Additional session judge and come special
Lord
judge,
Mr.
POCSO
P.
Kamrup
Goswami,
Metro.
learned counsel for the appellant. This is an appeal against the judgment dated 11/23, passed by the Court of the Special Judge Udalguri in Special POCSO Case number 61/2019, by which the appellant has been convicted under section 376(3) IPC and section 4 of the POCSO Act. Admit the appeal or matter after 4 weeks.
Yes.
Then in the IA, right, Mr. S.H. Bora is granted 4 weeks time to file an objection to the application under section 389 CRPC.
It is, my lord. My lord, this matter, my lord, the honorable court has allowed me to take steps such as to distribute public as per order. And there is no corroboration logic. Even then the informant and the PW2, they are the same family member.
You want
father
the
and uncle.
Here goes. It's a paper book is there. This is item 11. Where is the pen? Where is item? This is item. 255 is not 556. 255. Is there any paper book? No, there's no paper book. No. Paper book. Well, I have checked all. Not 25.
LCR is there.
Yes, is there anything against the Abul Hussain?
Lordship, on the last occasion, if I remember it correctly, since the LCR was not there, I made a prayer. Take this matter along with the LCR.
Okay,
Today, the matter, LCR has come.
okay.
Let them start. I'll go to the LCR. If they have
No, yes, so is there any evidence against you?
Nothing.
Lordship, according to the judgment, there are two eyewitnesses to the occurrence, PW1 and 5, and which is corroborated by the medical evidence.
What does 1 and 5 say?
1 and 5, from the LCR, I'll bring it.
And lordship. And 5 lordship and 1, no corroboration lordship. When the 5 is and 5 and
What do they say? I'm not talking about corroboration. I want to know what they say. What have they said?
in my appeal petition lordship, page number 27 lordship. And there I start from 20. And in 21 lordship, the course examination.
Just a minute. There is no Abul Hussain. Unless he has got a different name.
Evidences are in Banikula.
No, I'm looking at the judgment.
Judgment is the PW one and five. Lordship, para 44 of the judgment, this page 55. And IA 657.
Para 44, yeah,
As stated above, PW one and five claimed themselves as eyewitnesses to the occurrence as they were present at the time of occurrence. So let us appreciate the evidence of PW one and five first. The evidence of PW one disclosed that the occurrence took place around 11/8/14, and on that day at about 9 p.m. he along with his brother went to give food to their father, who was staying at Shilongani to look after their cultivation. At that time, one neighbor, Muhammad Raham Ali, called upon their father to his house for discussing some boundary issues. Lordship, Raham Ali is one of the appellants in item number 12.
no, I'm talking about Abul Hussein. This is
Lordship,
11.
let us see, my lord. After 1 hour, they heard some halla in the house of Raham Ali. Then, when they went to the place of occurrence, they saw that their father was assaulted by the accused Raham, Mumtaz, Niamat, Kudrat, Karamat Ali Hussain, Akkas, and Nabi Hussain with a heavy wooden object. Thereafter, they, some instance, moved forward and informed their elder brother Aminul Haq and uncle Akkas Ali over telephone about the incident. According to him, they can identify the accused person after 5-10 minutes. Their family members came there and they went to the place of occurrence and they saw that the accused person killed their father and the father was lying there on the ground. And when the accused person saw them, they fled away from the place of occurrence. Defense failed to demolish this above evidence by cross-examination. PW5 fully corroborated the evidence of PW1, and here also defense failed to demolish his evidence by cross-examining him. Raham Ali called upon their father to his house for discussing some boundary land dispute. After 1 hour, they heard some halla in the house of Raham Ali. Then, when they went to the place of occurrence, they saw that their father was assaulted by the accused Raham, Mumtaz, Niamat, Kudrat, Karamat, Ali Hussain, Akkas, Nabi Hussain with a heavy wooden object. Thereafter, they some instance moved backward and informed their elder brother Aminul and uncle Akkas Ali over telephone about the incident. According to him, they can identify the accused person. After 5-10 minutes, their family members came there and they went to the forensic. Lordship, may I see if his name Abul Hussain has been uttered by some witness or not?
Page number 20, like in appeal petition, page number 27, and para number 20, Lordship and PW5, rule. I can just for a moment, Lordship, I am getting the para number 21, the close portion of the witness number 5.
Page?
Para number, page number 27, no, in my imminent appeal petition. Para number 21.
Yeah.
And the
Sir, 21.
close part of the PW5, no. Para number 21. Page number 27. Para number
Yeah.
20. And during the cross examination, he stated that is not a PW5, Nurul Haq Lordship. And the exhibit
I've not heard that.
police did not mention any injury on the person of his father, and he stated that he did not know the numbers of the sons of Idris Ali have. His father testified that no wife stayed with his father, and he stated that one wife was dead, one stayed with them, and other two were left the cohabitation of his father. Therefore, his father charged his wife day and night for left him, and he denied the fact that Roham Ali did not call his father and for discussing some the boundary left. And Lordship, and finally come to Lordship P2P2 in my judgment section, judgment Lordship.
Just a minute, just a minute. I don't know.
Lordship, I'm looking at whether his name appears. I think there's
Doesn't
an
appear-
order for.
Doesn't
Lordship.
appear.
Let us see. Land dispute was there. Akas, Abu Hussein and Ali Hussein. There's a lot land dispute.
Maybe land dispute, but then Abu Hussein is not
Lordship,
one
let
of
me
the
see.
perpetrators.
One thing is very interesting, what you say, the PW1, the son
Huh?
of the, one thing is very interesting, the PW1 informant, and he is the son of the deceased. He said his father is died, and subsequently his another son, the younger brother of the PW1 informant, he said that his father was not dead, was alive, and they brought to the hospital. But PW1 called the PW2.
That's a yeah.
Just like veracity of statement.
He died anyway. At the end
Not-
of the day, he died.
Involvement part. Concern.
Lordship, I'm looking at. Lordship, but it's vernacular. Evidences are in vernacular. My lord. I have not gone through the entire evidence.
Is Ali Hussein and Abul Hussein same person?
No, no.
Because
Abolition, his father
in
name
the judgment, Abul Hussein's name is not here. I mean, in that first page. But inside it is there. No, it is here. But out here, Ali Hussein's name. Ali Hussein's name is not. So is Abul Hussein and Ali Hussein the same person?
Abu Hussein. এটা কোন নাম থেকে?
The issue is whether Ali Hussein and
Something
Abul
would
Hussein are the same person. The-
Lordship, Lordship. I'm just trying to look at the 313 statement. Abul Hussein, son of Idris Ali. In 313. Son
No,
of
no.
Idris Ali.
We want to know if Abu Hussein and Ali Hussein are the same person.
Same in one person. Abul Hussein, son of Samsuddin. Ali Hussein is different. Ali Hussein, Muhammad Samsuddin. Another accused, charge sheeted accused.
In that case, you come to the judgment, main judgment. The first page. Ali Hussein's name is not there.
Abul Hussein was an absconder. It was his name is in the this one, in the raiding, my lord. Abul Hussein. He was an absconder. Lordship, he was an absconder.
Who was the responder?
He's one Abul Hussain. In the charge sheet,
Maybe,
yes.
maybe he was
Subsequently,
responder.
he was charge sheeted, formal charges.
Maybe yes, even if he was the responder, the evidence would have to show his complicity in the crime.
Oh.
That nothing is there against Abul Hussain.
Okay. Difficulty is that it's in vernacular, my lord. And it's difficult to read the evidence.
If you find it difficult, imagine how.
Oh, no, my
difficult
lord.
it is for me.
But it should have been translated. I think there's an order. Sure about it. It's possible the order. Huh?
My lord, para number 4 of judgment. Para number 4 of judgment.
Para number 4 of
Four.
judgment. Yes.
On appearance of the accused persons by Raham Ali, Mumtaz Ali, Niyamat Ali, Kudrat Ali, Keramat Ali, Nabi Hussain, and Abul Hussain.
So there is no Ali Hussain. Oh, then the case of the accused Akash Ali Hussain was filed on 27/8/15. So they are different.
I
Because Akash, you come to para 4. The case of accused Akash Ali and Ali Hussain was filed on 27/8/15. So they are different persons. In para 4.
Doctor, I think there was an order for to translate the
We have said registry to prepare the paper book.
I because it's vernacular, my lord. Evidences are in vernacular.
Whatever it may be, there has to be, you see, that the learned trial court would have to have a basis for convicting the Abul Hussain. But the evidence which has been reproduced in the judgment nowhere suggests that Abul Hussain had anything to do with the death of the deceased. That's all I think.
Lordship, may I please
I think the three items have been declared. Yes, 15 items have been mentioned. Before that, what is your name? Mr. F. Hawkins. In item 11, Mr. F. Hawk appears for the applicant appellant. While Ms. B. Puya, additional 50 appears for the.
May I please, Your Honor? But I'm appearing for the sixth petitioner here. Particularly there are three vital witnesses. PW 1, 3, and 5. They appears to be they claims to be the eyewitness of the whole offense. 1, 3, and 5. 4 is the doctor. As per the doctor's evidence, there is only a single injury on the head. Apart from that, there's not even a bruise. Single injury. But this victim, my lord, he was in search of his wife at that time. Then accordingly, he went to the house of the one of the accused persons. Then the PW3, there is some hue and cry that the PW3 is the eyewitness to the whole occurrence. He went to the place of occurrence. He saw that the deceased, he suddenly fell down on the ground. Then there is one more witnesses was not examined by the police, but the defense's witness. He is probably the Gaupura. That's what I say, you know. So as the village headman, he was also present by the PW3 man. PW3 man. So
DW3.
PW3, Siraj Master, he is the headman. He was also present at the time. So there's a hue and cry when he fell down on the ground. Then he informed the PW1 and PW5 over phone. Then after half an hour, they have reached to the place of occurrence and they have implicated all the sons of the rest of the along with the courtyard. Actually, it has fallen. This is the actual case, my lord. The lot, my lord, PW3, my lord. Lord, you kindly see the PW3 that is on page 96.
Page 96.
In the IA.
Page 90.
6. 96. Mary. I know the informant Mainul Haq. I know the accused person. They are the neighbors of the same village. I know the deceased Matlab Ali. His house is located 2 doors down from my house. The incident took place around 1 year back. On the date of occurrence, I was sleeping after taking dinner. I did not have a clock in my house. I heard hue and cry outside my house. I went to the place of occurrence after hearing the hue and cry. The place of occurrence near is Rahman Ali's house. Many people had gathered at the place of occurrence. Siraj Master Jamaluddin asked Matlab Ali what was going on there. Then Matlab Ali said he had come in search of his wife, which is Matlab Ali, the deceased. When Siraj Master made a phone call to his sons of Matlab Ali, then the Matlab Ali fell down. The sons of Matlab Ali, namely the Aminul, Nurul and Mailul, came to the place where the Matlab Ali has fallen down. His family members, Matlab Ali's family members, attended to him by giving him first aid. After that, Matlab Ali was picked up and taken away by his son. Later on, I came to know the Matlab Ali had died. The police did not interrogate about the incident. I know the sons of the Matlab Ali had filed an FIR against the 9 accused person. The FIR was lodged against the person who was present at the court today. Cross part near the house of the accused and the Matlab Ali, there are the houses of Razia Khatun, Sultan, Mainuddin, Siraj Master, and his brother Asghar Ali, Kitab Ali, Abdul Rahman, many other persons. There are about 60-70 houses. The shops of the Shafiqul and Bilal are also situated near the place of occurrence. Shops are grocery shop and the tea stall. The houses are congested, having no fencing. Apart from the 3 sons of Matlab Ali, the other people who had come to the place of occurrence are known to me. I do not know the rest. The sons arrive half an hour after the Matlab Ali has fallen unconscious on the ground. Akas Ali, who is the brother of the deceased Matlab Ali, lived nearby. Shiraz Master, who called Akas Ali, Nurul Haq, Mainul Haq, and Aminul Haq come to the Matlab Ali together. Matlab Ali had fallen near the house of the Rahman Ali. Later, he picked up and taken to the road. The others had fallen near to the shop and Sensu Bilal. Thereafter, I went to the book. Matlab Ali has married six, 7 times. At that time, due to the incident, none of the wives was with him. The last one had also left. Matlab Ali used to keep searching for his wife. Matlab Ali fell unconscious when the Siraj and Kamaluddin had called his son. This is basically the eyewitness version.
Who is PW1?
PW1 is the informant son of the Matlab Ali, my lord.
8.
Page, my lord. It starts from in the mind. 73.
Mainul Haq.
Yes, my lord. I am the informant of the case. The addition to the Rahman Ali, Mumtaz Ali, Qudrat Ali, Rahmat Ali, Abul Hussain, Akas Ali, Ali Hassan, Nabi Hussain, and Niyamat Ali, all are accused in this case. I have filed the case against 9 persons. Today, Rahman Ali, Mumtaz, Niyamat, Karamat Ali, Nabi Hussain, Qudrat Ali are present. The 3 others are absent. Accused persons are neighbors as well as the distant relation. The incident took place around 1 year back on 11th August 2014. On the date of occurrence, I, along with the Nabi Hussain, has traveled to our father's house at Shilangani and on a motorcycle and had taken food for him. We went to around 9:30 p.m. Our father lived alone in the Shilangani and had fields and ponds there. When we reached the delivery food, our father, his next door neighbor Rahmat Ali, called him to his home to discuss some boundary dispute. We watched TV for almost an hour in our father's house. Then we heard screams from Rahmat Ali's house. My brother and this is very important, this part. We watched TV almost an hour in our father's house. Then we heard screams from the Rahman Ali's house. My brother Nurul Haq, I went out and saw that Rahman Ali, Mumtaz Ali, Niyamat Ali, Qudrat Ali, Keramat Ali, Ali Hassan, Akas Ali, Nabi Hussain were assaulting in the courtyard of their house. They were assaulting using the heavy wooden object. There were other people.
Just a minute, wait. Just a minute. Wait. Where are you reading? Page?
74. Well, basically from PW1 and 5, their case is that they went to the house of the deceased on that fateful night at around 9:30. With to the father's house with the food. Then the father asked them to wait inside the room. And they have watching
And
TV.
he went to the neighbor's house.
And he went to the neighbor's house where the occurrence took place on the courtyard. And they are watching TV at the time of the incident initially. Then after he went dry, they went out and saw the incident. That is their basic take, PW1 and PW5. They are corroborating to that effect, my lord, basically, that they are inside the house, they are watching TV. After hearing, now, this part is absolutely, my lord, for the first time they have implicated that they are watching TV, they went to the house of the deceased. Now, the PW3, he said that they have been informed over telephone. That's for the PW3. They were informed over telephone. Then after half an hour, they came to the place of occurrence. Now Lordship kindly turn to the IO.
Just a minute, before that, again.
Yes.
Let's go to PW3, where does it say after half an hour?
Yes, after half an hour. PW3 said after half an hour.
The sons arrived after.
Page 97, my lord. From the bottom, Lordship will find in the fourth line. Haji Lordship.
Who is the Siraj master?
Siraj Master is the neighbors. Lordship, now kindly see one thing before I come to the Siraj Master, my lord. Just Lordship, I want to have a look at the PWA, the IO, page 143. Because this part is very important. As per the PW 1 and 5, they were watching TV inside the house. Then they came to know about the incident on the hearing here, hue and cry. Then they now the 143, the cross-examination while the what IO has said to their previous statement. 143 PW1, my love. Aminul Haq did not state before me that the electric light was on at the time of the incident and that he had identified the accused person under the light. The witness also did not state before me that his father stayed at Silangani. The witness also did not state they had taken food. He also did not state that they were watching TV when Rahmat Ali was called away, his father. It is very important. He also did not state that he had called his family members over. I had recorded the statement of PW2. That's not important, my lord. Then PW5 again. Next page, my lord. PW5, Nurul Haq, page 144, my lord, first line. PW5, Nurul Haq did not state before me that his father has asked him to sit while he went to Rahmat Ali's house. The said witnesses did not state before me that he was watching TV in the house of his father. He also did not state before me that the time of incident at the light of the courtyard of Rahman Ali was on. The said witness also did not state before me that the father was being assaulted by a heavy object and they had gone ahead to stop the assault. The said witness also did not state before me that he had informed his uncle about the incident over the phone. The said witness did not tell me that 6 people had come from the Dhing gate up to the place of occurrence. The witness did not say before me that he had seen his father in an injured condition in the courtyard of Rahman Ali. The witness did not state that he, along with his uncle, carried his father to the shop from PO. The witness did not state that the father had told him that his son Idris Ali has beaten. So, for the first time, PW1 and PW5, who has claimed to be the eyewitness, has indicated that they were present at the time of place of occurrence, in the house of the father. Rather, the PW3 belied their statement, pilot. He said they were informed and they were.
But PW1, there is nothing to show that he did not see the incident. That has not been put to him.
Yes, but their suggestion was there, my lord. But these cases that basically they were present inside the house.
It's their own house.
In the father's house, their own house, my lord. The father's house, they're watching TV because the father has asked him to sit there. Accordingly, they were watching TV, and then when hue and cry, they went out and saw the incident. Their basic claim is that then they have found that the only person has assaulted his father, whereas the other witness is the more natural witness, my lord, the independent witness PW3, the neighbor, other neighbor, he has said that their presence itself, they have been informed by the Siraj master. Then after half an hour, they came to the place of occurrence. They took the father to the hospital. That's the case of the. So there are two versions of the prosecution case. There are three eyewitnesses to the occurrence. The PW3, the independent eyewitnesses to the occurrence, said that both the PW1 and 5 came later on to the place of occurrence. And the PW3 version has been corroborated by the PW3, Siraj Master. So his version is that, yes, I was there. I accordingly the disease fell down on the ground. I informed the son over telephone. They came to the place of occurrence later on. Apart from there are other witnesses there. We have examined all as a PW because there are lots of people in the place of occurrence. Prosecution, the investigating authority, though they have been examined, but did not examine in the court. So later on, we have examined as a PW witnesses.
PW1 and 5 are the sons.
Son.
of the district.
Yes. So, and the 3 is the independent witness. Now, as per them, everybody assaulted. And this is a case of 34 by 302. The common intention. So in the evidence, there is no common intention that there is a previous meeting of mind. And there is as far as the evidence of the doctor lordship, kindly see page 37. PW4, my lord, page 37 from the judgment I am reading. Paragraph 18. In our page 13, page 37. Dr. PW4 in Narendra Bhagavati was testified on so. He has deposed the postmortem so Ali found the body in the short condition. The rigor mortis present. Both the eyes was closed, mouth was also closed. Wound over the body was not found. This is very important. Wound over the body was not found. As per the PW1 and 5, all the accused person with the heavy weapon, he has been assaulted. Fracture of the skull, that is the important. The fracture of the skull bone present over the upper middle part of the occipital lobe of the skull, So this is the only injury, only one single injury. That is on the head. And the PW3 has explained what is the reason for that injury. Because he fell down on the ground itself. And so popular evidence and the medical evidence that the only person has assaulted with a heavy weapon, which has been implicated by the PW1 and 5, it doesn't corroborate with the medical evidence. So the Lordship also notes that while convicting the accused with the aid of 34, the participation is necessary or the prior meeting of minds is also necessary. It is the duty of the prosecution to establish prior meeting of minds. There is no prior meeting of minds regarding the presence and the participation to the actual commission of the offense. There is only a single injury. If we believe also, the one for PW1, rather 3 said, sorry, 5 said there is only one person has assaulted the disease on his head. That is, my lord, the Damanani, as per his version. So I think, my lord, this is a big case for my lord bail at this stage because there is every possibility of the acquittal in this case.
First, may I take your lordship with the involvement how this Abu Hussein came into the picture? Lordship, may I take exhibit 6 if his name was uttered by one Nurul Haq, my lord? Nurul Haq is my lord PW5. In his, we have found 164 statement. Here, your lordship may not be there. It is not ethics. So they have not-
164 statement.
It's the part of the record, my lord.
But 164 statement is, has it been,
Exhibited, exhibit 6. 11/2014 তারিখে রাত্রি 9টা
no, but then what, has it just exhibited it or just he has reiterated the contents of the 164? Has he reiterated the contents of 164 statement in his evidence or just exhibited the document?
PW PW5. He has named Abu Hussein along with other accused persons. Alright. And one more Moinul Haq, my lord, who happens to be PW, my lord.
But then PW5, what has he said?
Yes, my lord.
What did he say? What did he
In
say?
PW1 in 164 statement has named Abu Hussein
Ah.
and PW 5 Nurul Haq.
Ah.
We have found his name.
Acha,
I
1 and
repeat,
5 have named.
you have 164 statement as regards the name of Abu Hussein. Moinul
But
Haq,
have they stated that in their evidence? No.
PW1 lordship learned, yes, relied upon,
PW5 stated.
yes. And your lordship prior, yes. So lordship, may I, if your lordship desires, I'll go through the evidence portion once more. 1 and 5, my lord. Lordship, although he has no specific name, PW1, but he's seen in number 3 line is vernacular. Assamese Raham Ali, Mumtaz Ali, Imtaz Ali, আর বাকি কেইজন আছিল একে গাঁৱৰে মানুহ। ঘটনা আজিৰ পৰা এবছৰ আগত 11/2014 তাৰিখে ৰাতি 11টামান প্লিজ। So he identified, there's dog identification, my lord.
There's no identification of Abul Haq. Abul
No, he
Hussein.
said আটাই কেইজন, all the accused persons. And regarding the prior meeting of mine, whether there's enmity, there's land dispute, my lord, along with Raham Ali, there was land dispute. And your lordship, regarding the single injury part, as regards the case of my learned senior friend, Mr. Bora, my lord. So his name is uttered by 1, 2, 5, 6, and 4. And your lordship, I have gone through the postmortem report. Your lordship, injury on various parts of maybe on the this one, the head. But fracture of the skull bone as a result of all the description, the column 2, my lord. Brain congested, hemorrhage, clotted cut present inside the upper middle part of the occipital lobe of the brain, size so and so. There are two sizes, 5 cm and 6 cm also in length, and transverse resection, spinal cord healthy, my lord. So there is more than one injury, my lord. One of 6 cm, one of 5 cm. There cannot be two sizes, one 5 cm, one 6 cm. Yes. Sir. So your lordship, and one more aspect, there, even if there might not be a specific overt act, may not be necessary because under 34, it should be vicariously liable. As such, they are routine, my lord, and learned the trial court is elaborately dealt with the evidence of 1, 2, 5, and 4, my lord, as well as doctor's evidence, and discarded the evidence of PW3 and 7. Lordship, and 161 statement, I am prohibited to do so. But if your lordship permits, because in most of the cases, what they do, the IO, because of the evidence given by the IO, my lord, although he is our witness, my lord, something is there in the record, in the 160 statement, they come before the court and deposes that it was not stated before him. So the prosecution case fails, my whether lordship would take into account the evidence of eyewitness, even if they are related to each other. Learned trial court has not relied upon the evidence of PW 3 and 7, has relied on the evidence of 1, 2, 5, 6, and 4. So, or if your lordship takes into account the evidence on record, lordship, it's a fifth case here, your lordship will not grant bail and will not suspend the sentence. And may I pray, since the LCR is on lordship is available,
Any weapon seized?
Caesar with, Caesar, my,
No,
may I see the, Caesar.
Page 102 is the PW4, my lord, his deposition. The doctor, there is only, as per his deposition, my lord, it is only a one injury on the head. Again, he said the wound over the body was nil.
No, there was not any wound over the body, but there was injuries on the various parts of his head.
Wound and injury is a different, I don't know, my lord.
Body, there was no wound. It hasn't, they have not mentioned it much.
I don't know, my lord, the wound and the injury, how it is differentiate. But anyway, the fracture of the skull,
About body and the, this one, head.
fracture of the skull bone present over the middle part of the occipital lobe of the skull, 5 cm length, transverse direction, vertebra healthy, membrane congested, clotted blood present over the membrane, over the upper middle part of the occipital lobe. Then hemorrhage, clotted blood present inside the upper middle part of the occipital lobe of the brain, size cm. That is the same injury. It is in the one is the in the upper middle part, occipital lobe, that's the same. Six cm is the size of the clot. That is the blood clotting part, my lord, that is 6 cm.
Yes, Ms. Bhuyan, what about the contradiction in the evidence of the PW 3 and 1 and 5?
The learned trial court,
PW3,
he has not discussed anything regarding why PW3 was discarded. No,
lordship,
and he was not even declared hostile by the prosecution. So it remains intact. And there are PW7 also. And the DW, all the DW witnesses, my lord, they have been cross-examined by the prosecution. So DW witnesses, we have to take it as the same value, my lord. And their presence is from the very prosecution witnesses also established that these witnesses are present during the incident. It's not an afterthought or they were brought later on to the case of offense. It's not a case.
lordship, according to the last, finished, let him finish.
Because our case is that, my lord, the simple case, my lord. It's the case of the PW 1 and 5. Their presence is doubtful because of the PW 3 and the medical evidence and the other witnesses, my DW. They are the interested witnesses. Land dispute was previous. They have implicated father resides alone. They have not stated before the IO that they were present inside the house. That is most vital. Why they have missed out that person in the IO, in the cross-examination. IO has strictly stated. If they were present in the house, they could have been said before the IO that yes, all of us, me and my brother, both were present at the time of incident inside the house. We came running outside, but they were silent about that part. For the first time, this part has been implicated in the court. So these are the evidence. It shows that their presence itself is doubtful. I cannot prove that much, my lord. Our duty is to just to prove it beyond, not beyond reasonable doubt, preponderance of evidence. I excuse. That's all.
Lordship, in para 45 of the judgment, learned trial court has elaborated why, lordship, because the defense could not demolish the version of PW 1 and 5.
No, but why, what about the PW3? What to do?
No, PW3 was discarded, lordship,
Where-
landed
Where
trial
is, where
court.
is it discarded? Where is the court discarded?
Because your lordship, the duty of the prosecution as well as the learned trial court, who is the best judge to judge a case, because before whom only the evidence take place, my lord, to take out the shape from the grain, my lord. So he, learned trial court is elaborated, may not be elaborated dealt with the matter, but relied on the evidence of PW 1 and 5, who is the most vital witnesses to the occurrence and defense could not demolish them, my lord. And in our 164 statement also, there are exhibited 164 statement, they have named this accused person, my lord, along with the Abu Hussein, who was the appellant there. So my respectful submission is that your lordship, I will present your application. Recently with your lordship and paper book be prepared, my lord, entire matter be taken up to here.
In as a part of it, right? Right, Mr. It is also for the applicant, I should prefer. But we do it to them. Order is a.
Public.
Order is a. It's not a difference, it's from the. Both the item. That's item is definitely. Yes, there is the council.
Yes, lord. Wait
I
for
thought
an
that they-
adjournment in the morning.
I said no.
Yes.
They don't come, they don't come, then we'll pass the order against them.
There's
As
oral
per-
time declaration, eyewitnesses to the occurrence, there's,
There are eyewitnesses.
yes,
Okay, Mr.
and there's one injured eyewitness.
No one appears for the appellant. Even though this court has rejected the prayer, the oral prayer for adjournment of the case. When the matter was mentioned in the morning. Post- The IA, yeah? Ms. B. Buyan, additional PP appears for the state. This is an application under section 389 CRPC for suspending the sentence to be undergone by the appellant from a pursuant to the judgment dated 30/06/2023 passed by the passed by the court of the additional sessions judge, Vilasi Para. Dobri. In second case number 211 of 2011, by which the appellant have been convicted have been convicted under sections four 58-302-323-34 IP and have been sentenced to undergo simple imprisonment. No, full stop. IPC, yeah, full stop. The four applicants have been sentenced to undergo simple imprisonment for 5 years with a fine of rupees 5,000 each, in default to undergo simple imprisonment for 1 month under section 458-34 IP. Putta. They have also been sentenced to undergo simple imprisonment for 2 months under section 323-34 IP.
Amila, I may be allowed to withdraw the IM.
Okay, right. Mr.
AM Ahmed.
M. Ahmed, learned counsel for the applicant. Says that he may be allowed to withdraw the. I,
Paperbook already.
Miss B. Buyan. Citizen PP submits that she has got no objection to this. Accordingly, the application for suspending the sentence under section 329 CRP is dismissed as withdrawn. Then you write in the main case, Mr. Prince appears for the appellate. While Ms. B. Buyan appears for the state. As paper book has been prepared, this is the matter for hearing in usual court.
Okay.
This Lordship. Lordship, according to, as per office noted 13/12/23, return notice no such person in the above address. But we have taken steps in the same address which was mentioned in the
Will issue notice there.
Lordship.
Right. Third, Mr.
MJ Kadir.
MJ Kadir, learned counsel for the appellant. Applicant.